the last case, Ozimek versus Rodgers. I think we have some of the same attorneys, right?
No, there is no.
It's
consolidated, but there's no.
Yeah, but it's only me, Your Honor.
Okay, so you have 7.5 minutes.
Yes.
Okay, please proceed.
Ann Argeroff on behalf of Vanessa Ozimek, appellant. I want to start off just very briefly saying I don't want us to maybe artificially conflate legal custody status with the decisions that come from having legal custody status. Mm-hmm. So legal custody status is one thing, but what does that mean? It means making the most important decisions we can about the most important people in our lives, our children. And I suppose on my deathbed, I probably won't be thinking about my cases, though I find them very important. I'm going to be thinking about my children and the decisions I made about my children. And the decisions themselves are an expression of that legal custodial right. And when we're talking about legal custodial decisions, we're talking about the important decisions. Under Michigan law, it's identified in 722.26a, the important decisions that joint legal custodians make. And those important decisions have always been identified both in terms of Michigan law and in terms of the United States Supreme Court cases as education, health, and religion. Religion is fundamental. Health is a fundamental concern when we're parents. Look at the recent vaccination case that might have come out of Macomb County, where I believe a mother was jailed for not having her child vaccinated. And education. And education is fundamental because where we're educated, how we're educated, what we're taught, what belief system we're taught in terms of education, what philosophies are taught, make us into the human beings and adults that we are. And it's fundamental in terms of how we develop as people. And these are the fundamental decisions that parents make. And that was recognized in Truxell. When Truxell said, you're dealing with the physical components and you're dealing with the legal components. So if we say you don't have an appeal of right about a legal custodial issue, like education, a fundamentally important issue, I think the state, which has inserted itself, and that's the other element of this too, when we're dealing with these issues, it's not the parents who are deciding. Now the state is inserted as a player. The state makes the decision. The court makes the decision. The court makes a legal custodial decision about someone else's child. The state is the actor. And the state is saying, either I agree with you, parent, or I agree with you, parent, but one of these parents, and this was the discussion in Hoskins about what does it mean if the state acts. And so the state is coming in, inserting itself. Michigan inserts itself into parental decision-making. They can decide in favor of one parent whose then ability to express their legal custodial right is attenuated and disrupted and affected. And it goes with the other parent, or it goes with neither parent. And under 722.241, the state has an obligation, a paramount duty to ensure the best interests of the child. What if you have a single trier of fact? You have your trial court judge, who is just one person, so they have all their subjective biases, decides something that neither parent would agree to. And then on a fundamental, I'm talking about an important issue. And I'm not saying that soccer isn't important. I've raised 2 kids. Music was important. Soccer was important. Cello was important. Lacrosse was important. But I'm talking about the fundamental important issues we've always recognized as a society: education, health, religion. So the state inserts itself, because it has to in a divorce or custody situation where there's joint legal custody, whether that's been agreed to by the parties or whether that's been imposed by court order. The state inserts itself and makes a decision that is contrary to what both parents would have wanted. There's no appeal of right there. And even if the state decides with one of the parents, the other parent's legal custodial status, that parent's fundamental, innate crucial right to make decisions on behalf of their child is affected. It's affected because the state said no. And the child is affected also.
This feels to me like, do you think we should be, I don't know when who came up with that language, but this feels like very ripe for an ADM process to me, where we can take input from the entire bench and bar about what, what makes, how that rule should be thought of, or whether it should be amended or changed.
Right, and I think that would be fine, too. But I want to just make sure that we all, and I think we all do, we recognize that, as Truxell said, perhaps our most fundamental liberty interest is the right to parent and the right to make the decisions concerning the care, custody, and control of our children. And if we're talking about what the court prioritizes as appealable by right, and again, under attorney fees, under 7202-6A4, you can appeal a $500 attorney fee award. And I'm not saying that that's necessarily wrong or frivolous. There may be real reasons for appealing that attorney fee award. But if we're going to identify what are important issues affecting families and children and what fundamentally affects us as human beings, then it's custody decisions.
So you've outlined what you think are fundamental rights, that when the parent cannot exercise their right to make a decision, that's appealable. Are there any exercises of custody that a trial court can deny that you believe are not appealable of right?
So any exercises of decision-making custody, what we've termed legal custody.
Yeah.
The decision-making
Legal custody.
Yeah,
correct.
Lacrosse and cello.
Yes, and listen, there has to be a line drawn somewhere, but we want clarity too, because we have cases that go through on legal custody and other cases that are in the exact same situation that don't. So we're dealing with potential due process violations where we have where we think arbitrary decisions, and we have no way of clearly counseling our clients to say, yes, you're going to have leave granted, or not leave granted. Yes, you're going to have your claim of appeal dismissed. For years, I filed both claims and appeal and applications at the same time, which is expensive for people who don't have a lot of money. I'm not dealing with a corporation, I'm dealing with a family. I'm dealing with a family that's been through divorce.
All of this, what Justice McLaurin says about an ADM makes a lot of sense. Like, maybe we need a rule that will mark out certain kinds of cases that are appealable and certain kinds of cases that aren't appealable. But like your counterpart, it sounds to me like you're making an argument that not granting appeal as of right with respect to education, health, and religion is a violation of some constitutional norm.
I think it may be.
So that would be an interesting argument, but I'm not sure it's the one you've raised.
Well, I didn't think we'd necessarily have to get there, but I think we did raise it in a general context that I think we're dealing with such fundamental rights. Now, I did talk about the due process and equal protection aspects of this. One, we're not dealing with something that isn't very clear, and so you've got arbitrary, you can't advise clients you don't know. Also with equal protection, that where we're dealing with fundamental rights and the failure to be able to express those fundamental rights because the state is the decision maker. And that, I think, is the key, that you have the state making these decisions concerning, again, the important decisions, education, health, and religion. So that's where you have.
So again,
and I think it does implicate.
If it's not those, would you say that it is not a decision affecting custody? If it's not one of those fundamental rights?
I say, in my world, everything affects custody. But we have to also understand that we're dealing with some.
But if this was an ADM process and we brought you in on behalf of the family law bar, is it possible that you might separate lacrosse from
Yes,
religion?
absolutely. I would separate education, health, and religion. Because when you look
I
at
understand
how-
you're here on behalf of a client, so I'm not.
Right, right. Well, and I think you've been informed, too, that in our case, the case settled, and the child is now in the Livonia School with our client, and they've worked it out. Now, it always is capable of repetition because there are going to be other there will be other, in that case.
I'm sorry, just can I stop? Your case settled and you no longer have any dispute?
We will have constant issues that may be capable of repetition in terms of disputes.
There will be future disputes, that I understand, but you
Yes.
no longer have a live dispute.
No, but we have a published case that's affecting my case and affecting every case in the state of Michigan that is being broadly applied, both broadly applied in terms of not just.
That would explain why you don't have an opposing counsel here, I suppose.
Well, I've never had an opposing counsel. All the way through, there's been no opposing counsel.
So we haven't opposed, right, so I guess,
We're confused, we didn't know that.
yeah, I wasn't aware that your case had settled.
Oh, I'd
So,
call.
Nobody told us that, yeah.
yeah, so your case has settled, meaning we have a published Court of Appeals opinion, but we don't have any live case or controversy, so
Well,
maybe
but
we
you
don't have.
You have a case that's, you have a situation that's capable of repetition. It's going to apply again in my case because the parties don't get along, and they're going to have subsequent legal custody disputes, so, and they can't decide a jurisdictional issue. But I just wanted to, if I'm here, I want to continue.
Well, I think your time is up.
Could I say one thing to answer your question, Justice Markman?
No, I think your time is up, unless there are further questions. Do you have something, Justice Lodge?
I was going to answer Justice Markman's question, please, Justice Markman, if I could. Your concern was affecting custody, and you thought there was a distinction between how you define affecting custody, physical custody, and whether, one of the answers might have been if legal custody affects physical placement of a child or physical custody, then it affects custody. My argument has always been legal custody status and expression of that legal custody status, and any order granting or denying an expression on the fundamental important issues of that legal custody status affects custody, and denials and grants of motions affecting physical custody also affect custody, because, number one, the word affect is broad. It was chosen to be in that court rule. And affect means, you put, in terms of physical custody, even if you deny, you're affecting the placement of that child. Legal custody, if you deny status or if you deny a parental decision on an important issue, that affects custody also.
Thank you.
Thank you.
Yes, sir.